Good morning, everyone.
Good morning.
29th,
Good morning.
2021 meeting of the Charlotte Zoning Board of Adjustment is now in session. I am Patrick Welch, the chairman. Also sitting on today's board is Ms. Deborah Dryden, Ms. Crystal Long, Mr. Douglas Wilson, Mr. John Floyd, Mr. Raghu Kotha, and Mr. Mark Williamson. Also present are Shad Spencer, zoning administrator, Lisa McCarthy, planning project manager, Terry Hagler Gray, senior assistant city manager, city attorney, Jill Sanchez Meyer, senior assistant city attorney, Max Oliver, clerk of the board, and Atkins court reporting verbatim reporter. I would like to start by acknowledging that we are conducting this meeting using a remote electronic platform. This is the 13th remote meeting of the Charlotte Zoning Board of Adjustment, and I would like to ask for your patience today as we proceed. There may be slight delays as we transition between speakers, participants, and presentations. The Zoning Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statute and the Charlotte Zoning Ordinance. We conduct evidentiary hearing on requests for variance and appeals, among other requests. Before we begin to hear the cases on today's agenda, I would like to provide some important information on the steps that were taken to ensure that each party's due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with special legislation passed by the North Carolina General Assembly and Session Law 2021-3 that allows for remote meetings and quasi-judicial hearings during declaration of emergencies. Second, each applicant was notified before being placed on today's agenda that this meeting would be conducted using a remote electronic platform. Every applicant on today's agenda has provided signed consent to the board prior to conducting the evidentiary hearing on their request using this remote platform. Third, notice of this meeting was provided to the applicants and the public in a number of ways. Notice of today's hearings was mailed to the property owners within 300 feet of each subject property and notified the property owners of the remote electronic platform, and the letters also stated to contact the city immediately if there was any objection to the cases being heard on today's agenda. Notice was also provided by placing signs on each property and by publishing notices on the city website. The notice for today's meeting contained information about means by which the public can access today's proceeding. Finally, any individual wishing to participate in today's evidentiary hearing were required to sign up prior to today's meeting, prior to today's proceeding. This information was also included on the board's website. Applicants for a variance for the regulation of the zoning ordinance. Applicants for variance for regulations in the zoning ordinance, the order of the recommendation agenda will be as follows. The zoning administrator or a zoning staff member identify the case and recommend approval of the variance with any recommended condition based on specific reasons. The chairman will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard at a later date. The chairperson will ask if the board has questions, staff, or if there is any reason the board wishes to move the case to regular agenda. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. The order of the agenda will be as follows. All parties who plan to give testimony pro or con will be sworn in. A zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for this case. The board may question the applicant, and the staff member may question the applicant. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak pro or con will be given reasonable time to present sworn testimony. The staff and the applicant will be given an opportunity for rebuttal. The chairperson called for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations. After hearing each regular agenda case, however, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff member after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits will be required to be provided to the board, to the clerk, no later than 12 p.m. on Monday, June 28. In order to be considered at this hearing, if your case is not appealed, the Superior Court after 30 days, you may pick them up, or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for the purposes of this hearing and can only accept sworn testimony. While the board would not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar had issued an advisory opinion that it is the unauthorized practice of law for an individual who is not an active member of the bar to appear for another or otherwise assist or represent another at a quasi-judicial hearing on the zoning and land use matter. All applicants shall have been provided with a copy of the advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of the opinion, please use the WebEx platform function to message the clerk to message the clerk document, and the document will be provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such a request at the start of that case. Appeals from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board written decision in which to appeal in accordance with the North Carolina General Statute 160A-388E. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form which must be filed with the board clerk or chairperson at the time of the hearing of the case. Please remember to mute your microphone when you do not intend to speak. You will hear 7 cases today, 5 recommendation agenda items and 2 regular agenda items. The first case, 2021-047940, Queen City Court, presented by Lisa McCarty.
All right, our first case is a residential rear yard variance request. The applicant is requesting an 8-foot variance from the required 45-foot rear yard for an existing addition to the principal structure. And I'll give you a minute to look at your findings if you want to just let me know when you've had enough time to review.
Mr. Chair,
Yes, ma'am.
have the witnesses, has Ms. McCarter been sworn?
No, ma'am, we can do that now. Do we have anyone else that intend to speak on this matter? Swear everyone in now.
I believe the applicant is here as well as their legal representation.
This is an item on the recommendation agenda, so they may not need to be sworn in yet because they may not need to present. But
Okay, Ms. McCarty, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, thank you.
and I do also. That's it. Just in case I need to speak.
Let the record show Mr. Spencer has also been sworn in. You may proceed, Ms. McCarty.
Exhibit number 1 is a vicinity map of the subject property. Exhibit number 2 is a zoning map. The property is zoned R3 single-family residential and is surrounded by other R3 single-family residential properties. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. There's a single-family home on the property that was built in 1997, compliant with the 45-foot rear yard requirements. In 2011, a permit was issued for a garage addition with a finished office space on the 2nd floor. The permit plot plan notes the required 45-foot rear yard, but also shows a distance of 37 feet between the addition and the rear property line. That's an encroachment of 8 feet. The addition was built with the garage and heated 2nd-story office space, encroaching 8 feet into the rear yard. The ordinance allows garages to encroach 25% into the rear yard, but this would not apply to the heated 2nd-floor office. Staff believes permitting staff may have thought the encroachment was for the garage and subject to the 25% encroachment provision. Exhibit number 6 is the variance request. The applicants now wish to sell the property, and the encroachment came to their attention through a survey commissioned by the potential buyers. The applicants are requesting an 8-foot variance from the required 45-foot rear yard to allow the addition to remain. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship doesn't result from actions taken by the applicant or property owner. A building permit was obtained for the garage and the office addition. The applicants state they were unaware of the 10-year-old home addition was non-compliant with the zoning ordinance. The hardship results from conditions that are peculiar to the property. The property is a corner lot, and the front of the home is oriented towards the street side yard of Queen Charlotte's Court, so the rear yard functions as an interior side yard. There's a public storm drain easement in the rear yard and topography resulting from a ditch, which creates a narrower permitted building area to place an addition. The granting of the variance does not impact public safety because the addition does not encroach in storm drainage or stormwater easement on the property. And the variance will not detract from the character of the neighborhood because the addition has existed in its current location for 10 years. Strict application of the ordinance will require the addition to be demolished, which will result in an unnecessary hardship. Slide number 8 is a photo of the property. And that's the end of my presentation. Please let me know if you have any questions.
Max, do you have anyone to speak in opposition of this case?
No one has registered to speak in opposition of this case.
Okay, for this case, our board members that will be voting will be Ms. Dryden, Mrs. Long, Mr. Wilson, Mr. Ragu, and Mr. Williamson. Do I have a motion to approve or deny this
I
variance?
move that we accept the variance.
And I will second that.
I have a motion by Mr. Wilson to accept the variance and a second by Mr. Ragu. Senator roll call vote. Mr. Wilson,
Wilson, yes.
Mr. Ragu,
Raghu, yes.
Mrs. Dryden,
Dryden, yes.
Mrs. Long,
Long, yes.
Mr. Williamson, okay, and the yes from myself. So this variance has passed.
Mrs. Dryden, I make a motion that we accept the findings and the conditions of law as written.
Thank you, Ms.
Long
Dryden.
seconds.
I have a motion by Mrs. Dryden to accept the facts and findings and a second by Mrs. Long. Senator roll call vote. Mrs. Dryden,
Dryden, yes.
Mrs. Long,
Long, yes.
Mr. Wilson,
Wilson, yes.
Mr. Ragu,
Raghu, yes.
and it'll be yes for myself. Facts and finding has been approved as written. Moving on to our next case.
Our next case is a residential rear yard variance. The applicants are requesting a 5-foot variance from the required 40-foot rear yard for an existing addition to the principal structure. And I'll give you a minute to look over your findings if you'll just let me know when you've had enough time.
Ms. McCarter, you can proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The zoning is R4 Single Family Residential, and it's surrounded by other R4 properties. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The single-family home on the property was built in 1960 and was compliant with the current required 40-foot rear yard. In 2012, a building permit was issued for a dining room and chimney addition to the rear of the home. The permit noted the 40-foot rear yard. Exhibit number 6 is the variance request. The applicants now wish to sell the property, and a survey commissioned by the potential buyers showed that there's a 5-foot encroachment of the 2012 addition on the rear of the home. The applicants are requesting a 5-foot variance from the required 40-foot rear yard for compliance of the existing addition. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship doesn't result from actions taken by the applicant or property owner. The permit shows the required 40-foot rear yard, but the addition encroaches 5 feet. The applicants state they were unaware the 9-year-old home addition was non-compliant with the zoning ordinance. The hardship results from conditions that are peculiar to the property because it is 140 feet in depth, which is lesser depth than most other 150 to 155-foot lots in the area. This decreased depth reduces the allowed building depth for the addition. Granting the variance does not impact public safety, and the variance will not detract from the character of the neighborhood since the addition has existed in its current location for 9 years. The encroachment is minor and not easily detected, with the heated portion of the encroachment being 3 feet in depth and the chimney accounting for the additional 2 feet. Strict application of the ordinance would require the addition to be demolished, which would result in an unnecessary hardship. Exhibit number 8 is photos. In the main photo to the left, you can see the addition. It's the little entryway in the rear with the chimney. And that's the end of my presentation. Please let me know if you have any questions.
Lisa, this is Doug. I have a question. The bottom right-hand picture, I'm assuming that's the front of the house?
Correct.
Okay.
Does anyone else have any other questions from staff or staff? Max, do you have anyone here wishing to speak in opposition of this variance?
No one is registered to speak in opposition of this variance request.
Could board members that will be voting on this case be Mrs. Dryden, Mrs. Long, Mr. Wilson, Mr. Ragu, and myself? We'll have a motion to approve or deny this variance.
I have a motion to approve this request.
I second it.
I have a motion by Mr. Ragu to approve and a second by Mr. Wilson. Sent to roll call vote. Mr. Ragu?
Raghu, yes.
Mr. Wilson?
Wilson, yes.
Mrs. Dryden?
Dryden, yes.
Mrs. Long?
Yes.
And along, that will be yes for myself. Variance has passed. Going over the facts and findings. Conclusion of law. Do I have a motion to approve the facts and findings and conclusion of law as written?
This is Dryden. I make a motion to accept the finding of facts and conditions of law.
I have a motion by Mr. Dryden to accept the facts and find the conclusion of law. Do I have a second?
Long second.
I have a second from Mrs. Long. Senator roll call vote. Mrs. Dryden? Mrs. Dryden?
Dryden, yes.
Mrs. Long?
Long, yes.
Mr. Wilson?
Wilson, yes.
Mr. Ragu?
Raghu, yes.
And a yes for myself. Facts and finding conclusion of law has been approved as written. Moving on to our next case. Board members also sitting on this case will be myself, Mr. Dryden, Mrs. Long, Mr. Wilson, Mr. Ragu.
Our next case is a residential rear yard variance. The applicant is requesting a 3-foot variance from the required 35-foot rear yard for an existing principal structure. And I'll give you a minute to look over your findings.
Mrs. McCauley, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The zoning is R5 single family, and it's within the boundaries of the Wilmore Local Historic District. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The home on the site was built in 2008, and the building permit notes the 35-foot required rear yard. The applicant purchased the property in 2016, and the survey from that purchase did not show a rear yard encroachment. Exhibit number 6 is the variance request. The applicant now wishes to sell the property, and a survey commissioned for the sale shows a 3-foot encroachment of the home into the 35-foot rear yard. The applicant is requesting a 3-foot variance to bring the home into compliance. Exhibit number 7 is considerations. It supports the requested variance. The hardship does not result from actions taken by the applicants. A building permit was obtained for the home, and the property has changed ownership 4 times since the home's construction. The applicant states they were unaware of the encroachment because it was not shown on their survey in 2016. The encroachment was discovered through the 2021 survey for the current sale of the home. The hardship results from conditions that are peculiar to the property. The property depth ranges from 92 to 97 feet, which is a lesser depth than most other lots in the neighborhood, which have depths of 132 feet or more. The granting of the variance doesn't impact public safety. The variance will not detract from the character of the neighborhood because the home has existed in its current location for 13 years. The encroachment is minor and not easily detected. There's a fence that screens the rear yard area from view of the neighboring properties in the Spruce Street right-of-way. There's a provision in the zoning ordinance that allows for an administrative deviation of a yard requirement up to 2 feet, but the encroachment is 3 feet, so it misses it by a foot and can't be remedied through this provision. The deck on the rear is 6.6 feet in depth, and if the 3-foot variance is granted, the deck would comply with the 25% encroachment allowance. The property is located in the Wilmore Local Historic District, and the Historic District Commission staff has indicated they don't oppose the request, and the 2008 home was constructed prior to the adoption of the district in 2010. Exhibit number 8 is a photo of the front of the property. And that's the end of my presentation. Please let me know if you have questions.
Are there any questions for staff? Max, do you have anyone here that are wanting to speak in opposition of this variance?
No one has registered to speak in opposition of this variance request.
With that being said, ask for a motion.
I make a motion, we approve this variance. Dryden.
Have a
I
motion
second it, Wilson.
Have a motion by Mr. Dryden to approve the variance and a second by Mr. Wilson. Send to roll call vote. Mr. Dryden?
Dryden, yes.
Mr. Wilson? Mr. Wilson?
Wilson, yes. Wilson, yes.
Mrs. Long?
Yes.
Mr. Ragu?
Raghu, yes.
And it'll be yes for myself. The variance has been approved. We will review the facts and findings and conclusion of law. Ask for a motion to approve the facts and findings and conclusion of law as written.
I do approve it.
Was that a motion, Mr. Ragu?
Yeah.
Have a motion by Mr. Ragu to approve the facts and findings and conclusion of law.
Long seconds.
I have a second from Mrs. Long. Roll call vote. Mr. Ragu?
Raghu, yes.
Mrs. Long?
Long yes.
Mr. Dryden? Mr. Wilson?
Wilson, yes.
And a yes for myself. Facts and findings conclusion of law have been approved as written. Moving on to our next case. Board member sitting on this case will be myself, Mrs. Dryden, Mrs. Long, Mr. Wilson, Mr. Ragu. Ms. McCarty, proceed.
The next case is a residential setback and rear yard variance. The applicant is requesting 2 variances to add an addition to an existing house on a non-conforming lot, a 22.5-foot variance from the required 35-foot rear yard, and a 2.6-foot variance from the 20-foot required setback. And I'll give you a minute to look at your findings.
Ms. McCarty, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The zoning is R5 single family, and the property is within the Wilmore Local Historic District. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property was subdivided in 1914. It's zoned R5, and there is a required setback of 20 feet and the required rear yard of 35 feet. There's a non-conforming single-family home on the property that was built in 1931 prior to the ordinance requirements, and it has an established setback of 4.7 feet and an established rear yard of 7.5 feet. Exhibit number 6 is the variance request. The applicant would like to add an addition to the side of the home. The applicants are requesting 2 variances for the addition, a 2.6-foot variance from the 20-foot setback and a 22.5-foot variance from the 35-foot rear yard. Slide 7 is considerations. Staff supports the requested variance. The hardship is not a result of actions taken by the applicants. The existing home was constructed in 1931 prior to current zoning regulations, and the applicants purchased the property in 2020. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. The hardship results from conditions that are peculiar to the property. The lot size is smaller than the current minimum lot size for the district. The minimum lot area for R5 is 6,000 square feet, and the subject lot is 4,601 square feet. The lot depth ranges from 66.5 to 57.5 feet, and the lot width is approximately 74.5 feet, which isn't really sufficient to accommodate an addition to the existing home within the allowed building footprint. Granting the variance will not adversely affect adjacent or contiguous properties, and the proposed addition would not exceed the existing setback and rear yard encroachments. Granting the variance will not alter the essential character of the neighborhood, and a variance was granted in 2016 for the neighboring property to the north for a 10-foot front setback and a 10-foot rear yard to allow the construction of a new single-family home. Exhibit number 8 is considerations. Further considerations are that the property is located in the Wilmore Local Historic District, so the addition will require HDC approval. The HDC is not opposed to the requested addition, and the project is on the July 14th agenda for their meeting, and the applicant's floor plan and elevations may change based on their review. No variance is needed for the side yard for the addition. They're proposing 2 feet between the property line that abuts the alley and the new proposed addition, but the side yard can be measured from the center line of the alley. Exhibit number 9 is a photo of the front of the property, and that's the end of my presentation if you have any questions for me.
I have a question, Lisa. If the HDC, if they end up changing the floor plan based on the recommendation from the HDC, will they have to come back to this board?
Only if they propose to exceed what they've requested with their encroachments.
Okay, thanks.
Are there any other questions for staff? Max, do we have anyone scheduled to speak in opposition of this variance?
No one has registered to speak in opposition of this variance.
I make a motion to approve.
I second the motion, Wilson.
I have a motion by Mrs. Long to approve and a second by Mr. Wilson. Send it to a roll call vote. Mrs. Long,
Long, yes.
Mr. Wilson,
Wilson, yes.
Mr. Ragu,
Raghu, yes.
Mrs. Dryden, and that'd be a yes for myself. So the zoning variance request has been approved. Now reviewing the facts and finding conclusion of law.
I make a motion that we approve the finding, facts, and conclusion of law.
I have a motion by Mr. Wilson to approve the findings and facts and conclusion of law.
Long seconds.
I have a second from Mrs. Long. Roll call vote. Mr. Wilson,
Wilson, yes.
Mrs. Long,
Long, yes.
Mr. Ragu,
Mr. Raghu is yes. Thank you.
and a yes for myself. Findings and facts and conclusion of law have been approved as written.
So it appears that Deborah Dryden is no longer on the meeting. Out. So that case passed with a 4-0 vote.
Mr. Williamson, are you available to sit on the next case?
Yes.
Yes, I'm here.
The next case, board members sitting on this case for myself, Mrs. Long, Mr. Wilson, Mr. Ragu, and Mr. Williamson.
The next request is a residential rear yard request. The applicant is requesting an 11-foot variance from the required 40-foot rear yard for an existing sunroom on the rear of the principal structure. And I'll give you a minute to look at your findings.
Mr. McCarty, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The property is zoned R4 single-family residential and has mostly R4 surrounding it with a little R8 conditional to the south. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. And exhibit number 5 is background. The subject lot was subdivided in 1988, and the plat shows a required 40-foot rear yard. The single-family home on the property was also constructed in 1988. Exhibit number 6 is background. A survey from 2007 shows that a screen porch on the rear of the home encroached into the rear yard, but didn't specify a distance. The zoning ordinance allows unheated extensions on the rear of a single-family home to encroach up to 25% into the rear yard, which is 10 feet for this lot. After that time, the porch was enclosed and converted into a sunroom, so it wouldn't be allowed the 25% encroachment allowance anymore for an unheated extension. The applicants now wish to sell the property, and a new survey commissioned for the sale of the home shows that the sunroom encroaches 10.8 feet into the rear yard. Exhibit number 7 is the variance request. The applicant is requesting an 11-foot variance from the 40-foot rear yard to bring the existing sunroom into compliance. Exhibit number 8 is considerations. Staff supports the requested variance. The hardship was not a result of actions taken by the property owner. The applicant states that a previous owner enclosed the porch and they were unaware of the encroachment. The hardship results from conditions that are peculiar to the property. The lot depth ranges from approximately 103 to 105 feet, which is smaller in depth than many of the surrounding properties that range from about 135 to 250 feet in depth. Unnecessary hardships result from strict application of the ordinance. The reduced depth of the lot creates a smaller permitted building footprint to place a sunroom on the rear of the home. The variance will not adversely affect adjacent or contiguous properties or change the essential character of the neighborhood. The sunroom's not easy to detect, and the footprint of the home won't change. Also in 2020, a variance was granted for a nearby property located at 3030 Somerset Road, and that was for a 50% rear yard encroachment allowance for a covered porch. And you can see to the left graphic where that's located. Exhibit number 9 is photos, and the top left is the rear of the home with the sunroom, and then the bottom right is the front of the home. And that's the end of my presentation. Please let me know if you have any questions.
Are there any questions for staff? Max, do we have anyone signed up to speak in opposition of this variance request?
No one has registered to speak in opposition to this variance request.
I ask for a motion to pass or deny the variance request.
Make a motion to approve.
Have a
I will
motion.
second it.
I have a motion from Ms. Long to approve and a second from Mr. Ragu. Roll call vote. Mrs. Long,
Long, yes.
Mr. Ragu,
Raghu, yes.
Mr. Wilson,
Wilson, yes.
Mr. Williamson,
Williamson, yes.
and a yes for myself. Variance request has been approved. Reviewing the findings and facts and conclusion of law. I ask for a motion to approve the findings and facts and conclusion of law as written.
This is Williamson. I make a motion to approve the findings of facts and law.
I have a motion by Mr. Wilson to approve the findings and facts and conclusion of law.
Long seconds.
I have a second from Mrs. Long. Send to roll call vote. Mr. Wilson, Mr. Williamson,
Williamson, yes.
Mrs. Long,
Long, yes.
Mr. Wilson,
Wilson, yes.
Mr. Ragu,
Raghu, yes.
and yes for myself. Findings, facts, and conclusion of law have been approved as written. I believe that was the last case on our recommendation agenda item. Before we go into our regular agenda item, I said let's take a 10-minute break. Everyone okay with that?
Yeah.
Okay. We'll take a 10-minute break.
Okay, this is. So where is it? I don't know if this one goes with then. Hi, honey. I'm good. Yeah, we're on a 10-minute. Yeah. And so I'm trying to figure out because I don't know, the internet went funky and I had to get out of it. So I don't know. And then by the time I got back in, I don't know
Miss
where we
Dryden,
were exactly.
Miss Dryden,
Yes,
you're not muted.
sorry.
No problem. Just wanted to let you know.
That means I'm on mute, right?
Okay, do we have everyone back?
Wilson is here.
Long's here.
Marshall's here.
Dryden's here.
Mr. Ragu, are you back?
I'm back.
Okay, moving on to our regular agenda case. It's case 2021-051. Board members sitting on this case with myself, Ms. Dryden, Mrs. Long, Mr. Wilson, and Mr. Ragu.
Our next case is a residential watershed buffer and rear yard variance request. The applicant is requesting two variances to add a roof over an existing deck, a 36-foot variance from the 50-foot Lake Wiley watershed overlay buffer, and a variance from the 25% encroachment allowance to allow a covered porch to encroach 60% into the required rear yard. And I'll give you a minute to look over your findings.
Ms. McCarty, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned R5 single-family residential and is located in the Lower Lake Wiley Critical Area Watershed Overlay. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background of the property. The property was subdivided in 1975 and contains a non-conforming 1976 manufactured home that predates the current ordinance requirements. It encroaches 21 feet into the 35-foot required rear yard and 36 feet into the 50-foot watershed buffer. Exhibit number 6 is the variance requests. The applicant wishes to add a roof over an existing deck using the established 36-foot encroachment into the 50-foot buffer. The ordinance permits unheated encroachments on the rear of the home to encroach 25% into the required rear yard, and that's 8.75 feet for this property. The proposed covered porch will use the established rear yard encroachment of 21 feet, and that's a 60% rear yard encroachment. So the applicant is requesting variances to permit the conversion of the deck into a covered porch using the established buffer and rear yard encroachments. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship was not caused by the applicants. The existing home is non-conforming, and the majority of the home and deck are located in the 50-foot watershed buffer and rear yard area. The hardship is caused by conditions peculiar to the property because of the lot's unique shape, with the rear of the property being an inverted V shape, and this causes the 50-foot buffer to cut into the middle of the property and limits the allowed building area, and you can see that on the bottom right. Granting the variance will not alter the essential character of the area because the requested variance will not exceed the established watershed buffer and rear yard encroachments. Granting the variance will uphold public safety. there's an impervious cement patio poured under the deck that is original to the home. So the addition of a roof above the deck will not increase the existing built-upon area on the lot. Mecklenburg County Stormwater Services does not oppose the requested variance because it will not increase the existing built-upon area within the 50-foot watershed buffer. Exhibit number 8 is photos. And that's the end of my presentation. And please let me know if you have any questions. We also have the applicant who has a presentation. And we have Ron Eubanks with Charlotte Mecklenburg Water Quality here too, in case there's any questions.
Do you have any further questions for, do you have any questions for the staff?
This is Mrs. Dryden. I just want to clarify, you say there's a concrete pad there already, so covering this, putting this cover over it will not enlarge the property at all. It just encompasses the already established concrete pad?
Correct. It will not add to the built-upon area. We do consider an expansion of the deck structure to add the roof, but they're not adding additional impervious. Over on the left side, you can see the survey on slide 6, and that little curved line that goes beyond the deck is where the cement is on the property.
Okay. Oh, I see. Okay. Thank you, Lisa.
We have the applicant on.
Yes, Mr. Chairman, David Murray, attorney with the Odom firm here on behalf of the Millers. Paige Miller, the property owner, is also here with me. And so Ms. Miller and I would need to get sworn in.
Okay. Do you both swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter at hand?
I do.
Yes, I do.
Mr. Miller, you may proceed.
Thank you, board. Again, my name's David Murray. I'm here on behalf of the Millers. I'm an attorney with the Odom firm practicing in land use zoning. Here today with me is Paige Miller. She is the property owner. And Ms. Miller, let me just ask you a couple of questions real fast before I begin the presentation. Have you reviewed the PowerPoint? And is it accurate to your knowledge?
Yes, it is. I have reviewed it.
And you have reviewed the application that was submitted in this case, and it's accurate to your knowledge?
Yes, I have reviewed it and it's accurate.
And I've been retained to speak and testify on your behalf. Is that correct?
Yes, that is correct.
Thank you. Lisa, I appreciate your presentation. Members of the board, since staff is in support of this variance, I would also adopt what Ms. McCarter has presented because you'll hear from me today, but obviously a lot of what I say will be repeating what Ms. McCarter has already said. Lisa, can you move forward? You can actually go to the next slide too, since you've already covered that. So background of the property, the house was built in 1976. As Ms. McCarter said, it's a manufactured home. The deck on the rear of the home and the patio below function is basically like a lounge patio area. It's not enclosed. Everything is existed that we're talking about today. Everything has existed in the same footprint since original construction in the 1970s. Miss Miller's parents actually own the house, and they're the ones that developed this property. And so she's seeking to renovate it to make it into a permanent residence that eventually at some point in time she'll likely move into. The house and the deck, concrete patio, as we've already heard, were constructed prior to the modern buffer rules being put into place on this property. Forward, please. This is our first exhibit. It's showing the area where the deck is currently located, and we'd be seeking to add the roof over the existing deck. Just to orient you, the deck basically backs up to the, I guess, the top story here. There's a basement with a garage beside it. And so the deck, when you see the pictures, pretty much lines up with the rear manufactured house that is on this property. Forward, please. This is a picture of the house, of the back of it with the deck. You can see the existing roof line is rather low on this property. As we said before, it's a manufactured house from the 1970s, so it does not have a very high pitch. It's a rather low pitch roof. And so the Millers would be seeking to bring the roof out to cover this deck area. It faces directly into the sun in the afternoon, and that's one of the reasons why they're seeking to cover this. Forward, please. This is another picture of the deck, just showing the actual planking of the deck. Forward. This is down below, looking back up at the property, and you can see under the deck there, you can see all the stone and concrete work that exists on this property with the stairs coming down. Forward, please. This is under the deck, showing the concrete and impervious area with the stone pillars that are the supports that support this deck. And so bringing the roof out over it, it's important to match up with the existing supports that are already on this property. Forward, please. This is an angle going a little bit towards the lake that again shows that it's open area with the impervious area. The impervious area actually extends beyond this deck. So the roof will actually not go to the edge of the impervious area. It'll only go to the edge of the deck. The impervious area actually extends beyond where the roof would go. Next, please. This is looking towards the adjacent property, showing the screening trees that have been planted by the adjacent neighbor. Those are probably about half the size of what they'll eventually be. This shows the stairway up to the side of the house. Next, please. As you know, when I present, I always like to review the variance standards here, because once we make a showing of each of these elements, the statute says the Board of Adjustment shall vary, shall meaning must, shall vary the provisions of the zoning ordinance upon a showing of all the following: unnecessary hardship, conditions peculiar to the property, did not result from actions taken by the applicant, and the variance is consistent with the spirit, purpose, intent of the ordinance such that public safety is secured and substantial justice is achieved. Next, please. Under unnecessary hardship, obviously, there's a lot of things going on here. First is that the lot was developed prior to the existing standards being applied to this property. So the impervious rules were not in place in 1976 when this was constructed. The area that we're seeking to build over for a roof was already built upon. Moving the house is not an option here, obviously. And also, as Lisa pointed out, I called it in my presentation, I'll call it a W-shaped lot. I believe Lisa called it a V-shaped lot, but it's the same thing. The buffer and rear yard lines, the measured lines come into the property in the middle, which creates a unique issue because the corners of the lot are much farther away from this house than the middle of the lot. And so we have a unique shaped lot. Forward, please. There's been other variances in this area that have been granted primarily because of unique shaped waterfront lots. Rear yard setback and buffer encroachments have been granted. Forward, please. This is a aerial from, I believe, earlier this year, showing this property. The access road into this property is a shared driveway. Approximately where Lisa's pointer is, there's a car there, and that is where the road veers off to this property. You can see the unique shaped property line. The rear lot line comes in very close to the house in the middle. And so that's what's creating the issues that have led to us needing to request this variance, even though we've already had something in existence since 1976. Because the new standards apply, we have to get a reduction of those standards in order to allow this roof to be built. Forward, please. The hardship here runs with the land. It's not personal to this applicant. It's not personal to the Millers. If I own this property, it wouldn't be personal to me or anybody else. It's directly related to the size, the location, shape of the lot, directly what the statute says. The lot has a unique W shape, which causes the buffer, as I've said, in the rear yard to be measured from a point deeper into the lot. And then the existing house, deck, and impervious area have been in the same place since 1976. This property is actually within the city's extraterritorial jurisdiction for zoning. It's actually not within the city limits. So when all this was built, it was actually within the county and not under city zoning anyway. Forward, please. This is not a self-created hardship. That speaks for itself. Ms. Miller inherited the property from her mother, and her mother had lived at the property for years prior to this. Everything was built in 1976, so the Ms. Miller page did not cause this hardship. Forward, please. Here, when we're looking at public safety, substantial justice, intent of the ordinance, we're looking at what is the intent of the reason for these buffers in these rear yards. And the reality here is the intent of the buffer rules is to preserve impervious area. However, because the roof being built over the deck doesn't increase impervious area, there would be nothing that would cause any public safety concerns here. As I've already identified, the concrete impervious area actually extends beyond this deck. So with the roof being built over the deck, it doesn't change any impervious area. In addition, the rear yard buffer is to provide spacing between structures. Here, again, the lake is to the rear of this property. It's not going to bring this structure any closer to any other property because there is no property to the rear. This is simply a rear yard exception to allow this roof over the existing deck that already is encroaching. So the denial of a variance here would only harm the property owners. It would not do anything to promote public safety. Forward, please. And finally, adding to a roof covering on this lakefront property would not cause any issues with the neighborhood. The deck and all the encroachments have already existed for decades. And all we're seeking here is to add a roof over the porch. If you look at houses that are adjacent to this, this house is small compared to other houses that are existing. Adding to the roof line is not going to cause any imposition on any adjacent properties. Further, it's normal and typical for lakefront properties to have covered rear porches and decks. And as I said before, some of the adjacent properties have rear covered porches and decks as constructed. Forward, please. So that is our presentation page. If you could come back on just briefly, let me know when you're back.
I'm on.
All right. Paige, do you fully adopt my statements, my testimony, and my presentation as if it was your own testimony and as if you had made it here today?
Yes, I do.
Thank you. Members of the board, in conclusion, we meet the 4 standards entitled to a variance. I want to thank you for your time. I want to thank Ms. McCarter for all her time working with us on this and her presentation. Please let me know if you have any questions, but we'd appreciate your approval of this variance. Thank you.
Thank you, Mr. Murray. Board, do we have any questions for Mr. Murray? Max, you have anyone sign up to speak in opposition of this variance request?
Yes, we do. We had 3 people sign up to speak in opposition to the request. I believe one is on the call. Jennifer Mackham.
Mrs. Mackham, are you on the call?
I am. It's Meacham also.
Meacham, I'm sorry.
That's
Mrs.
okay.
Okay, before you begin, I'll just go ahead and swear you in, Ms. Meacham.
Okay.
Ms. Meacham, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter at hand?
I do.
Okay, Ms. Meacham, you may proceed.
So we are neighbors with the Millers, and I guess just to bring up a few concerns as someone in the neighborhood. And I wanted to point out before I got into this that there may have been more people. I realize that you send letters, but when the zoning sign was placed, it was placed in a well-located area where anyone that was driving down the street could have seen it. And shortly thereafter, the sign somehow was moved kind of into an interior location on the property and facing away from the road. So I don't know if it was, if people had maybe missed the notice from that, or, junk, thinking it was a junk mail or something like that when they got the notice in the mail, but I would like to point that out. But I also would like to say that, as mentioned several times, the home and the porch is within the 50-foot buffer. And I know that from my own personal experience, anytime that you need to alter or modify any type of existing structure, or place an addition to something within that 50-foot buffer, Duke has very stringent requirements on that there will be no alterations or additions that can be made within that buffer zone. And as Mr. Murray pointed out, once there are several exceptions, and as a neighbor, that is a concern of mine that if this is allowed for, again, this will just open the door to other properties in the area that will need similar variances and exceptions, and will ultimately detract from the overall, visual effect of Lake Wylie and how in the preservation of the shoreline. So the other issue that I like to bring up that was mentioned several times is that this is a modular home, and it was a 1975 modular home. Again, Mr. Murray did bring up the point that this is a small structure compared to other existing structures nearby. I would like to, kind of rebut that argument, and that this is actually, if you were to drive around lake, this 1970 modular home is very much in line with what was put on the lake during those times. And there are other newer structures nearby and within the neighborhood that are have been upgraded and are more, current with architecture and building pads and that kind of thing. Also, Mr. Murray did bring up that some of the adjacent properties have covered areas, covered porches. Not all. It is definitely not a necessity. And one of the things that was that was not presented in any of the pictures was the large tree canopy that the adjacent property to us has, that the Miller's property has, and it is actually very shaded. I did not come prepared with photos or anything like that. I'd be happy to provide those at a later date if that's needed. But the property does itself have a fairly large, well-established tree canopy that buffers the house and the deck from the elements. I guess one of the other concerns as a neighbor is that there are very limited details of what is to be completed on the property. There's no plans, and nothing has been laid out. So it's difficult from, I would think, from anyone's point of view to be able to approve something that it's not known what is being asked. I know from also, again, personal experience, I renovated in Dilworth, and before anything could be approved, we had to have very detailed plans, drawings, and presented to the board before we could even move forward to a hearing. So I think those are the points that I wanted to cover today, and I appreciate everyone taking that into consideration. Thank you.
Members of the board, David Murray here. Given that this is quasi judicial, I have to put my objections to opposition testimony on the record. So I'm objecting that it's immaterial and speculative. Ms. Meacham, I did have a question or two for you. Your mother is Patricia Gleason, is that correct?
That's correct.
Okay, and she's also a co-owner of the property next door with you, correct?
Yes, her name is on the deed.
And y'all have sought to purchase the property from my clients?
Miss Miller came to us asking if we'd be interested in purchasing it, and seeing as we have a family home on this side that is multi-generational, we were interested in having other members of the family within proximity as well.
Miss Miller is the owner of the property, and she has not been interested in selling this property at this point, correct?
Oh, I don't know. This was maybe a year or so ago that she had approached us asking if we would be interested in buying it, and to come. She showed up at the house. She and her husband gave us a tour of the home, and then asked us if we were interested to send a bid to her, if we were interested, which we did. And at that time, she said that she wasn't interested in selling.
And since that time, have there been issues between with the access road to the property, that there have been vehicles from people at your property blocking access into the Miller's property?
I fail to see how this affects variance for roof covering.
Well, it's because of the fact that since the Millers have been there, the intention has been that y'all have not liked the fact that that house is next to your property, and you have opposed everything that they have tried to do, including getting access to their property.
Sorry, we have not opposed anything that they've tried to do. And during construction, it's very difficult to, especially as was shown in the photos, with very narrow entrance road, it's very difficult to direct large trucks where to park if you're not here all day. And we did our absolute best to manage that situation at all times. I would also like to say that this is speculative and is not related to the variance case at all. And I'd like to move on to the next question if you have one.
Lisa, can you move forward with the members of the board? I just want to, just for the record here, this is marked as Exhibit 9. It should be Exhibit 10. This was the request to purchase the property. And if you could move forward, Lisa, to the next exhibit. This is an aerial picture of the two properties. Prior to 2019, there was nothing next to our property. This is the house that's been built next door. It's built right up along the side property line. And you can see the dock has been placed. It's substantially bigger. A couple other things I would note about the property next door is that there's several covered porches, so it would not be inconsistent here to have a covered porch on the back of this property. If you could move forward to the next slide, please. This is just a front view showing the adjacent properties. And this would be the Meacham and the Gleason property. Members of the board, again, I would ask that you would support this variance. We've met all the standards here for granting this variance. I'm happy to answer any questions. And Ms. Miller, if you have anything else you'd like to add, please do. But again, board, I appreciate your support of this. Ms. McCarter, I appreciate your support, and we would request that the variance be granted. Thank you.
Thank you, Mr. Murray. Thank you, Mrs. Meacham. Does any member of the board have any questions for either Mr. Murray or Mrs. Meacham? Seeing there's no questions, I move that we go ahead and close deliberations and discuss this matter. Okay, the meeting is now in closed deliberations. Okay, going.
Well,
And
this
no,
is Mrs. Dryden. I thought Max said there were 3 people who wanted to speak in opposition. I only heard Miss Meacham. Was I incorrect in hearing that?
There were 3 registered to speak. Only 1 is in attendance today.
Okay, thank you, Max.
okay, in no particular order. Again, further discussion is variance request. Mrs. Dryden, your thoughts?
I can see where Mr. Murray is saying that, the property next door has covered porches, but it looks like they're well outside the buffer. That home looks like it's set back quite far, much farther than the home that we're discussing today. So I don't know that that's a point that we need to dwell on. I would like to have some assurances that the coverage that they put on there is not going to be huge and detract from, they're going to attach it evidently to the roof line of the existing home. And how the water runoff from that roof is going to affect the watershed. I don't know who would answer that, but those would be my questions as we move forward.
And Mrs. Dryden? Mrs. Long?
I don't have any additional thoughts over what Ms. Dryden just said.
Okay. Mr. Wilson?
Yeah, I agree with my colleague, Mrs. Long. I don't really have anything else to add from what Mrs. Dryden mentioned.
Okay, Mr. Ragu?
Yeah, I don't have any additional questions from my side too.
Okay. As for myself, I, again, just looking at the pictures, being that I don't believe that the covered porch is again, it's not going to add any additional footprint. It's just basically going over what's already there. Again, I don't see any issues with approving the variance based off of my, again, I don't think they're adding any more footprint to it. They're just basically actually adding over what's already there that's existing. So first, I don't see any issues in approving the variance. But that being said, are you guys, again, as far as the board members, are you wanting to ask any additional questions or wanting any assurances? We have to come out of closed deliberation to get those answers. Or is anyone wanting to make a motion to approve or deny the variance as requested?
I'll make a motion to approve the variance as requested.
Second it, Wilson.
I have a motion by Mrs. Long to approve the variance as requested and a second by Mr. Wilson. Senator, roll call vote. Mrs. Long?
Long, yes.
Mr. Wilson?
Wilson, yes.
Mrs. Dryden?
Dryden, no.
Mr. Ragu?
Raghu, yes.
And a yes for myself. The variance request has been approved. Reviewing the findings
Thank
and
you,
facts.
members.
Reviewing the findings and facts and conclusion of law. Is there a motion to approve the findings and facts and conclusion of law as written?
I make a motion to approve the findings of fact and conclusions of law.
I have a motion from Mrs. Long to approve the findings and facts and conclusion as the law.
I will second that.
I have a second from Mr. Ragu. Roll call vote. Mrs. Long,
Long, yes.
Mr. Ragu,
Raghu, yes.
Mr. Wilson,
Wilson, yes.
Mrs. Dryden,
Dryden, yes.
and a yes for myself. Facts and findings conclusion law have been approved as written. Moving on to our next case, case number 2021-053. Board members sitting on this case will be myself, Ms. Dryden, Mrs. Long, Mr. Wilson, Mr. Ragu.
The next case is a residential rear yard variance request. The applicant is requesting a 16.6-foot variance from the 30-foot rear yard for an existing addition to the principal structure, and I'll give you a minute to look at your findings.
Mr. McCarty, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The property is zoned MX1 mixed use, and that's a conditional zoning district. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. In 2005, the property was subdivided and a single-family home was constructed on the property. In 2016, the applicants obtained a permit for a covered patio addition to the rear of the home that noted the required 30-foot rear yard. A covered patio to encroach 25% into the rear yard, and that's 7.5 feet for this property. Staff believes the permit was issued under the assumption that the addition would not exceed the 25% encroachment allowance. The applicant states that the covered patio was enclosed approximately a year after construction, so the 25% encroachment allowance is no longer applicable. Exhibit number 6 is the variance request. The applicants now wish to sell the home. A survey commissioned for the sale of the home shows the addition encroaches 16.6 feet into the 30-foot rear yard. The applicants are requesting a 16.6-foot variance from the 30-foot rear yard to bring the existing addition into compliance. Slide number 7 is considerations. Staff finds that the variance request does not meet the criteria within the zoning ordinance for granting a variance. The hardship was a result of actions taken by the applicant. The building permit for the addition specified that there's a required 30-foot rear yard for the property. The covered porch would have initially been subject to the 25% encroachment provision of up to 7.5 feet before it was enclosed, but the encroachment exceeds that 25% allowance. The 16.6-foot encroachment is a 55% encroachment into the rear yard. Since the covered patio has since been enclosed, the 25% encroachment allowance is no longer permitted. There is an area within the allowed building footprint on the right rear of the home where an addition could be located. There's no evidence of practical difficulty or necessary hardship, and the property appears consistent with other properties within the surrounding community. The hardship's not peculiar to the applicant's property, and other homes in the area appear compliant with the rear yard. Also, I would like to note that the variance application notes a 1.6-foot encroachment into the required 15-foot tree protection buffer. But the tree protection buffer is not a zoning ordinance regulation, so no variance from the 15-foot tree protection buffer is necessary from the Zoning Board of Adjustment. Slide number 8 is a photo of the property. The property is a gated community, so I had to take it from the outside, the closest right-of-way to the property. And that's the end of my presentation. Please let me know if you have any questions.
Lisa, I have a question.
Go ahead.
This is Dryden. Explain to me again the difference between when they just built a patio and the 25% in buffer and the encroachment was possible, but when they closed it in and covered it, it was not. What makes the difference?
Okay. So the difference is that it's heated finished space. So with a patio, you can encroach that 25% because it's unheated space. It's an extension of the home, and that's the provision from Section 12. And once you enclose that structure, make it heated space and a part of the principal structure, you can no longer have that encroachment provision. But this one, we think it could have been permitted under the assumption that it would have fallen into that 25% when it was unheated. It extended what was allowed even at that point. So 25% would have been allowed. It was 55%. So it didn't even meet that when it was unheated.
Okay, looking at the picture that you're showing, where did they cover? I see the brick patio.
So-
I see right there, that area. Okay, thank you.
Right in here.
Yes. Okay, thanks. Thank you.
Do we have any other questions for staff at the moment? Max, you have anyone?
Hi, this is Scott Flegel. I am the new owner of the property.
Yes, sir. You said Mr. Fiegel?
That's correct. It's spelled F-L-I-G-E-L.
Oh, Flegel.
And
Okay, Mr.
so
Flegel.
this, can I speak or do I need to?
Yeah, I need to swear you in.
Yes, sir. Yes, sir.
Mr. Flegel, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter at hand?
I do.
Okay, Mr. Flegel, you may present your presentation.
Sure. So we just closed on the property and moved in yesterday. The previous owner, Mr. Benting, had gotten the permit, as Ms. McCarter had said, and also received HOA approval to add this. There is no one behind us, and the neighbor beside us, this doesn't infringe on anything with their property. The additional plan standpoint, we're requesting that the variance be approved and that it doesn't affect anyone behind us or beside us.
Were you finished, Mr. Flegel?
Yes, sir, I'm finished.
Max, do we have anyone signed up to speak in opposition of this variance request?
No one has registered to speak in opposition to this request.
Does any of the board members have any questions for Mr. Flegel?
So just to be clear, Mr. Flegel is not the applicant, correct?
That is correct. I am the new owner, and during the process of buying it, we wanted to, wasn't, I don't know all the legal terms, but when the attorneys wanted to get the zoning approved, they said that for us to have title for a variance in future years, if we were to sell the property, that we would have to go through this process. So I was informed that, this was going on. So I wanted to attend today to hear, and this is my first time attending a meeting like this. So I don't know if I knew the answers to all your question, but yes, I'm not the previous owner had applied. And so I just am here listening, and obviously the new owner, we just moved in yesterday.
So you closed knowing that this was in violation.
That is correct. So we went through and we talked with our attorneys and went through, and they looked over all the documents and felt because of the situation that we were located and what has happened in the neighborhood with other that they felt like this would be something that could get approved as far as getting the variance to in our favor. Yes.
Mr. Fleeg, we're having a hard time. It's like you're cutting in and out.
Okay, sorry. So can you hear me better now? I'll move a little closer. Is that better or not?
Yes, much better.
Okay. I'm just getting internet connected, so I'm just moving a little closer to the computer, that's all. So did you hear what I said before?
Can you repeat that, Mr. Fleegle?
Sure. We went through with closing on the property and met with our attorneys, and they felt confident based on the variances in the neighborhood that had been approved, that no one was behind this or that this didn't impede on anyone beside us, that from that standpoint that they advised us that it'd be okay to go ahead and close, and we wanted to go forward with the right format to get the zoning approved. And so Mr. Oliver was nice enough to give us the link today, and so I wanted to attend and speak on our behalf.
Mr. Fiegel, this is Shad Spencer, the zoning administrator. You stated that y'all have closed now on the property.
Correct.
We just get on record, do you consent to this variance request?
Yes.
All right. Is your wife also on the phone as well?
Yes, so she is here as well. So
and she consents to the variance request also?
can you hear us okay? Can you hear us okay?
Hey, Mr. Legal.
And you consent to this variance request?
Yeah.
All right, thank you.
Okay, does any other board members have any questions for Mr. Fleegle before we move to go into closed deliberations?
Mr. Chair,
Yes, ma'am.
I would just suggest that maybe Ms. Fleegle be sworn as well.
Thank you. Mrs. Fleegle, are you on the line?
I am.
Okay, Mrs. Fleegle, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in this matter at hand?
I do.
Okay, thank you, Mrs. Fleegle.
Thank you.
Mr. Chairman, I have a question, but it is for staff, and I'm not sure if I'm allowed to ask those questions now. I'm assuming I am.
Yeah, we haven't closed deliberation yet, so yes.
Okay, all right. And this question, I guess, would be for our attorney as well as Mr. Spencer. Is it, and I know that you asked for consent from the Flegels, I'm just wondering, are we able to even consider a vote on this request, given that the applicant themselves are not even here to give the reason as to why this variance should be approved? Maybe I'm out of my jurisdiction on this, but I kind of feel like it's, I guess you can say, unfair to Mr. DeFligos to come in and to defend this this recommendation when they don't really have, from what I'm gathering, all the necessary background on the variance.
I'm not sure why the applicant is not here. Max, have we heard from them at all?
I had communication with them last week to get the signed consent waiver. I emailed them this morning when I realized that they were not on the call and have not had a response.
Technically, at this point, which is why Mr. Spencer asked the Flegels for their consent, they are the property owners. So they, you know, I would think that they have jurisdiction to pursue the appeal, since they are now the property owners as of yesterday.
I would agree with Mr. Wilson that the concern here is that the hardship was a result of the actions taken by the Benzings, and they're not here to speak to that. So that's
Yeah.
that's
Yeah, I agree with Mr. Long. That's hard. I don't know if I would suggest, and I'm not sure if we are in the right realms for this, but I would suggest if there's a way we could have this table to the next meeting and allow the new property owners to consent more with their legal team to come back with a presentation as to why the variance should be approved. I just don't feel comfortable voting either way today because I feel like that they've been put in a position. Now, granted, again, I know that they closed in the house and they spoke with their attorneys, but I feel like they've been put in a position where they come here to present today and they don't even have all the facts, and I don't think that's fair to them. Again, I may be speaking too plainly on this, but this is just my observation.
That's certainly within the board's discretion.
And I agree with you, Mr. Wilson. Again, I think the new owners, like I said, will put in a position that, again, they don't have all the facts on why the hardship happened. So I agree that this should be tabled and give the new owners more time to consult.
Okay. Question to our attorneys: we are allowed to do that, right? Terry and Mrs. Sanchez Myers.
Yes, I would say that if someone wants to make a motion to continue this to the next meeting to allow for additional information, then that would be an appropriate motion.
Okay. All right. Well, I'll make a motion that we table this to the next meeting to allow the new homeowners time to meet with their legal counsel to come back and present.
I have a motion. I have a motion from Mr. Wilson to table this to the next meeting and a second from Mrs. Long. Roll call vote. Mr. Wilson?
Wilson, yes.
Mrs. Long?
Long, yes.
Mrs. Dryden?
Dryden, yes.
Mr. Ragu?
Raghu, yes.
And a yes for myself. So a motion has been passed that we table this to the next meeting to give our new owners opportunity to speak with their legal team and come back with a presentation.
Thank you. When will the next meeting be?
It will be the last Tuesday in July, which is July 27th.
Thank you very much.
I believe that's all the cases that we have on the agenda. Our next order of business is to approve the May regular meeting minutes. Do I have a motion to approve the May regular meeting minutes?
Mrs. Dryden, I make a motion to approve the minutes from our May meeting.
I have a motion from Mrs. Dryden to approve our minutes from the May meeting. Do I have a second?
Long
Second by
second.
Wilson.
I have a second from Mr. Wilson. Roll call vote. Mrs. Dryden?
Dryden, yes.
Mr. Wilson?
Wilson, yes.
Mrs. Long?
Long, yes.
Mr. Ragu?
Raghu, yes.
And a yes for myself.
Mr. Chairman, just a question. For our next meeting, we are in person back at the Government Center, right?
Actually, that was going to be our next order of business to kind of get the consensus of the board on, is everyone okay with coming in next month for our in-person meeting?
Yes, what
Mrs.
is
Dryden, I'm in
protocols?
favor.
Just curious, what are protocols for masks and whatnot?
The masks are not mandated. They are recommended. They just follow the CDC guidelines. So, if not vaccinated, then the request you wear a mask, but if you are vaccinated, you're not required to. We did reserve this room that we're in today, which is room 267 on the second floor. It's larger than the other room that some of y'all haven't even been to a regular meeting, but our normal meeting was in room 280, which is a large room as well, but this one's bigger so we can space out the tables more separation.
I just want to make a comment that I believe when your meeting occurs in July, we would still be under the governor's state of emergency. As long as we're still under the state of emergency, you still do have the option to attend remotely. So I think your chair is asking the will of the body, but I do want to make it clear that if you are uncomfortable and would like to participate remotely, you would have that option as long as we're under a state of emergency from the governor.
Will we have to make a motion to vote on having a hybrid meeting then in person with the option of being remotely?
I think you just have to let Max know so that he can make accommodations if you don't plan to be in the building.
Okay, gotcha. And that's for individual members. Okay, got it.
Yeah.
Okay.
So Max, when would you need the board members to let you know what their preference is?
If some board members aren't comfortable coming in, then we will have to give out notices that it will be a remote, or I guess in this case, hybrid hearing, and make accommodations for that. So if everyone is comfortable coming in, I think we can proceed as normal as prior to the pandemic. But assuming we're hybrid, I'll need to know basically by the end of next week.
Yeah, so some board members, if you're not aware, if it is a virtual hearing, there's some extra steps that staff will need to do in order to contact the applicants and get their consent to a virtual hearing. And so then if they don't consent, then their hearing is then continued to a certain date where we will have in-person meetings. So we just need to know soon enough so we can take those measures.
Okay, I think our last order of business is the revisions to the rules of procedures. think, wait.
And I don't know if Jill was gonna go over any of that. I think she sent out the proposed changes. So this is an opportunity. So if you have any questions or concerns, we can discuss it at this time. But the current rules of procedure says we present them now, and then we, if everybody's fine with those, they will be adopted at the next meeting.
Yeah, I'm available if y'all have any questions about any of the statutory changes or the changes to the rules.
Are there any questions about the revisions to the rules?
I have no question.
This is Frieden. I don't have any questions. They look, I mean, it looks like all you've, for the most part, you've just codified in what we're already doing.
Yeah, I don't have any questions either.
Same here.
Okay, Ben, there's no other questions. I think this concludes today's meeting. Are there any questions before we adjourn for today? Being there's no question, I want to thank each and every one of you guys for attending. And again, our next meeting is July 27th. July 20, okay, perfect. July 27th. Again, thank everyone for attending, and this meeting is now adjourned.
Thank you.
Thank you.
Thank you.